Hi, everyone. So today we are having our monthly Q&A session. If you have immigration questions, this is your opportunity to ask me and I'm going to answer it. If you have questions, please put them in the comments. If you are watching on the replay and you have questions, go ahead and put it in the comments because I do go back and look at your questions and answer your questions. And it helps other people too when you ask questions because they may be shy with asking questions on a public forum like YouTube or Facebook. So it's really good for you to ask me questions and I get to answer them because, like I said, that's what this Q&A session is all about. Let me tell you about myself. I'm a US-based immigration lawyer. I'm Lillian Chukura. I help my clients get green cards and citizenship for themselves and their family using the US immigration law system. So the way these Q&A sessions work, you can ask me questions live in the comments, and I already have questions that I'm going to go through. So if I'm discussing a particular question and you have follow-up questions for me, please do go ahead and ask me so that we can get the most out of this. So remember, ask me questions in the comments so that I can answer your question. Especially if you're watching live, it's really for you to get your questions answered right away. Okay. So let's get started. Like I said, I have questions already that people want answers to. So this, the things I talk about may apply to you. It may not. You may have your own questions. Put them in the comments. All right. So the first question I have here is I had a customary marriage and put my spouse in my B2 visa application. I'm now married to someone else and they're applying for a green card for me. Does the customary marriage count? Yes. There's not even another way to put it. Yes. If you got married, it doesn't matter if it's a customary marriage. It doesn't matter, if it's not in court, registered, whatever. As long as you are considered married where you got married, you are married. So a customary marriage counts as a marriage. I don't know, there's different cultures that think that a customary marriage is different, right? In most countries, a customary marriage is different from a church wedding, right? It's different from a registry wedding. However, it still counts as a marriage. So, like all marriages, you still need to end it. So, you still need to show proof that that prior marriage, even though it was a customary marriage, ended. So, for you to get a green card through your now spouse, you have to show that the prior marriage that was a customary marriage legally ended. So you need to look at your culture and look at how do customary marriages end in my culture and make sure that you follow those steps to end that marriage. Because if you don't, USCIS is now going to recognize your current marriage. So a customary marriage counts. An additional thing to keep in mind is if you are applying for a fiance visa, and then you go ahead and do a customary marriage while the fiance visa is pending, you no longer qualify for the fiance visa because now you are married. I've seen this happen several times where because people are waiting so many, it may take a year for the first part to be approved and then you're waiting for them to get their visa. You're like, okay, let's go ahead and do the traditional marriage because it's not really, a registry marriage. It's not really going to church and doing that marriage. So it wouldn't really count. Well, for immigration, for US immigration purposes, that customary marriage counts And because it counts, you now no longer qualify for a fiancé visa, because fiancé visas are for people that are not married. Okay. So it's really good to know this before you get into, deciding whether to do a customary marriage or not. Know that it counts as a marriage. So you can decide, if you're already in the fiancé visa process, you may want to hold off until your fiance gets here and you get married here, and then do the traditional marriage, instead of doing that and leading to you now not being able to get the fiance visa. Okay, you do not want to be in that situation. So make sure customary marriage counts as a marriage. And two, if you are going to be marrying someone else, that you end that customary marriage before you marry someone else, or the second marriage doesn't count for US immigration purposes. All right. If you're joining me and you have immigration questions, please put them in the comments. I am more than happy to respond to your questions. All right. My second question here is, if my case with my first wife is denied, would that affect my case with my second wife? Well, it depends on the reason that your case with your first wife was denied. So if it was denied because USCIS thinks that, your case with your first wife was fake, right? That the marriage with your first wife is fake, and that's the reason they denied your case, then yes, it's going to affect your second marriage. But if the reason they denied the first one was because, your wife didn't, your spouse didn't make enough income and therefore didn't have enough to do an affidavit of support, and that's the only reason it was denied, then it may not affect you. All right. Every single marriage, whether you file a green card application through that marriage or not, whether you file a green card application through that marriage or not, is going to affect, okay, every single marriage, whether you file a green card application through that marriage or not, is going to affect subsequent applications through, your second, third, or fourth wife. Because USCIS has the right to look at all prior marriages. USCIS has the right to look at every single time you've been married to see if you married that person, just so they can file for you, just so you can get immigration benefits. And this is even if they never filed for you. That's how much power USCIS has when it comes to prior marriages. Even if the spouse does not file for you, if they suspect that you married that spouse just so they can file an immigration application for you, not because you wanted to actually build a life with them, they have a right to deny your current case. So if they deny it, you still have a chance to try to fix it. However, to fix it, you need to prove that that first marriage, that second marriage, whatever it is, those prior marriages were entered into in good faith, and you had every intention of building a life with your spouse. And you can show that with documentation. Of course, the longer the time frame is between your first one and your second one, it's going to be a lot harder to get those documentation. So let's say it's been 15 years since the first marriage. It's going to be hard to get documentation from that time frame, but it's not impossible. And I work with clients to figure out what we can produce to help show that that first marriage was real. Okay. But if that's not the reason the case was denied, it shouldn't affect the second one. But USCIS can always use the first one against you. So only enter into a marriage for the intention of building a life together. Okay, not for immigration purposes, because it can come back and bite you. Next question. Who can be a joint sponsor for a green card case? Anyone that's a US citizen or permanent resident can be a sponsor for a green card case. Okay. So if you are petitioning for a parent and you don't have enough income and you are, your cousin, your friend, um, your neighbor is willing to be a joint sponsor, they have to be a US citizen or permanent resident and meet the income requirements. That's really it. They don't need to be, your relative. They don't need to be married to you. They can just be anybody that's a US citizen or permanent resident that is willing to do an affidavit of support for the beneficiary, knowing that doing an affidavit of support has some legal implications for them and they're willing to sign. That's all you need. Okay. So, affidavit of support, you just need the person to be US citizen or permanent resident. They do not have to be related to you in order to do the affidavit of support. All right. If I am in immigration court and I'm married to a US citizen now, can I get my green card? Great question. It depends. Okay. The great lawyer answer to everything, right? That's the lawyer answer to every single question. It depends, but y'all know, I tell you what it depends on this, on this program. I tell you what it depends on. It depends on how you entered the US, right? If you entered the US with a visa and then ended up in immigration court, if you entered the US with parole, right? Humanitarian parole, and then you're in immigration court, depending on the type of parole, if it's humanitarian parole, you would be able to get a green card through your spouse. However, the question becomes, is it going to be, are you going to have to apply for the green card in immigration court, or can you apply for it with USCIS? If your notice to appear, which is basically the charging document, the document from ICE that says this is the reason we're putting you in immigration court. If the notice to appear says that you are an arriving alien, that means you can file your green card application with USCIS. If it says that you are not an arriving alien, that means you can only file an I-130 with USCIS, wait for that to be approved, and file your green card application with the court. And the judge gets to decide on your green card application. So basically, if you entered with a visa or you were paroled into the US, you are able to apply for a green card. However, if you are an arriving alien, you get to do it with USCIS. If you're not an arriving alien, you get to do it with the immigration judge. If you were not, now let's talk about the people that entered without inspection, that did not come in with a visa, and were not paroled into the US. So if you entered without inspection, you're not married to a US citizen, go and watch my video from Tuesday on how a US citizen can file for their iwi spouse, because you still have to follow those steps: the I-130, the waiver, and finishing the visa application process at the embassy. But now there's an additional step, because if you are in immigration court, you cannot apply for an I-601A waiver. If you're in immigration court, you cannot apply for an I-601A waiver, which means you need to get your court case terminated or administratively closed after your I-130 is approved. And if it's terminated or administratively closed, you are now able to apply for an I-601A. So I-130 approved, terminate or administratively close your court case, apply for an I-601A waiver. Once that's approved, you can apply for the case to be terminated. You can travel for your visa interview. Okay, it's just an additional step that you have to go through when you're in immigration court and you entered without inspection. All right, let's see. Okay, next question. How long does a person have to be a citizen before they can file for their spouse? I love this question, because people think that, there's a waiting period. There's a time that you have to wait before you can file for your spouse, and there's not. right? If you become a US citizen today and you're already married to your spouse, you can file for your spouse, right? A US citizen day one and a US citizen year 20 have the same rights, right? Just because you just became a US citizen does not mean you don't have the same rights as someone that's been a US citizen since they were born. You are still a citizen. So, as a citizen, you can immediately, the same day, that's why I tell people, the same day you become a citizen, you can file for your spouse, you can file for your parents, you can file for your children. The same day you get your certificate of citizenship, your certificate of naturalization in your hand, you can file the I-130 for your family member. Okay? You can file an I-130 for your siblings on the day that you get your naturalization certificate. So really, there's no waiting period. Once you have that in your hand and you are sworn in as a citizen, you are a citizen. You can do everything a citizen can do. So if you are joining me and you are getting value out of this, please go ahead and hit the like button. And please ask me your questions in the comments. All right. I'm here to answer your questions. I'm here to give you information. So if you have immigration questions, put them in the comments. If you're watching on the replay and you have questions, put them in the comments because I am going to respond to you and include it in next month's Q&A. Next question. How long do you have to be married before you can file a marriage based green card application? This is another great question. Okay, it's another great question because once you get married, technically, you can file the same day. But what I like to tell people is you have to be prepared to file, right? Just because you got married, that may not mean that you're ready to file. So you need to figure out, do you have enough documentation of your relationship? Do you want to wait a few more months before you file, or do you feel comfortable filing with what you have? Here's the thing. You can file the same day. Some people feel they can't, but you can file the same day because you just need to show that you entered into your marriage in good faith. And yes, you don't have a bank statement together. You may not have a lease together. You may not have tax returns together, right? That's what people are afraid of when they say, can I file? How long do I have to wait before I can file? You just have to show that you entered into your marriage in good faith. Your dating relationship up to the point of your marriage is a show of good faith. Right? So it's not just the evidence that USCIS wants, it's not just from the date of marriage and on. Evidence from before you got married, leading up to the marriage, the relationship you had leading up to the marriage counts. If you were living together before you got married, that counts. If you had a joint bank account before you got married, that counts, right? So don't just think about your evidence for your relationship from the date that you got married onwards. It's your relationship as a whole. So even if you filed the day you got married, the day you got your certificate, you can still prove your relationship with everything that happened before that day, right? Before your wedding day, everything that happened before that, your relationship before that, leading up to you to getting married counts. So you do not have to wait. I tell people this all the time. You don't have to wait. But if it makes you feel more comfortable to have that joint bank account, to have that, tax returns, or whatever it may be, do that. But realistically, you don't have to wait. It's just most people feel that they need those bank accounts and all of that. The reason I also say you don't have to wait is because you have, your documents from your relationship, you also have time between the time you file and the time there's a decision in your case to get those bank accounts, to have your joint tax returns, to have your lease together, to have all those other things right? Because you don't file today and your application is approved the next day. It can take a few months. So in those few months, you can have, you can set all those things up, right? You can start building your life together and, combining your assets and all those things. Because USCIS may send you a request for evidence to get more documentation of your relationship. So you want to use that time frame to get those things together. So don't feel that you have to wait 5 or 6 months to get all those things together before you can actually file. That's not right, because you have those time frame to get those things together in case USCIS asks you for more evidence. In case you have an interview, you can take those things to the interview. Okay? So the day you get married, you can technically file as long as you have documentation of your relationship leading up to the marriage. And then you build up the evidence, those bank statements, and all of those things afterwards to prepare for a request for evidence or an interview. So basically, you don't have to wait. All right. So the final question I have here, listen, if you're joining me and you have questions, please put them in the comments. I am going through the questions that I received ahead of time. So if you also are listening and you want to send me questions ahead of time, you can do that. Okay. You can certainly do that. So go ahead and you can DM me with your questions on Instagram, Facebook, TikTok. I don't mind. Right? Send me your questions ahead of time and I can answer them if you don't feel comfortable asking in this forum. Okay. You can also ask me your questions in the comments if you have questions and you're joining me. If you're watching in the replay and you have questions, go ahead and put them in the comments as well. Because again, I'm here for you. I'm here to answer your questions. All right. So if I don't see any comments, I'm just going to go to my last question here. How can I get proof of my green card or my immigration status if I have lost all my documents? This is a big one. And I've had, like, I think in this month alone, I think I've had like up to 10 people have this issue. If you have lost your documents, if you've lost your visa, you've lost, everything that shows how you entered the US, everything that shows that you did get a green card or you did apply for a particular thing, and you just don't have any records, there's something called a Freedom of Information Act request. FOIA request, FOIA request. You can make this request with USCIS. You can make this request with CBP, so Border Patrol. You can make this request with the State Department. That's the State Department handles embassies and visas. Okay. You can make this request with basically every single government agency. Every single government agency has a way for you to do a Freedom of Information Act request. I've done it with the Social Security Administration when clients were not sure if ever applied for a Social Security card, they just weren't clear on their status. You can do a Freedom of Information Act request just because you want to know what USCIS has in your immigration file. This is why I tell people, you have one A file, right? US immigration keeps a file on every single person that has ever applied for an immigration benefit. I have an immigration file because I came here as an immigrant, right? So if I wanted a copy of my file to see what was in there, right? What was filed for me? How did I come to the US? All those things. When did I get my citizenship? I would do a Freedom of Information Act request with USCIS, and I would ask for my entire A file. So usually when you go on there, it will have, and you can do this request online or with a form called a G639, right? So you can either create a USCIS account and do the request online, or you can fill out the form and mail it in. Online is better because it's going to be faster. All right. There's no fee for this. That's the best part. There's no fee unless like it's been you're trying to get records that is just hard for them to produce and they charge you. And usually when you're signing and saying that you're making this request, they will let you know, are you willing to pay up to $25 for these records if we have to charge you for it? $25. Come on. $25. Okay. So it's not really, a huge fee, but most of the time I have not had one FOIA request where the government actually charged the fee. Is it possible? Yes. But typically, no. Okay. So you would go on the website or with the form and ask for specific documents or your entire file. If you just need, a copy of a specific form, a copy of a specific document, you can request that. But if you want to see everything that USCIS has in your file, you need to go down and select other and put an entire A file. That's the only way. If you start checking boxes, they will only give you the things that you specifically ask for, unless you go ahead and select other and put your entire A file. I usually suggest people do this if they've had previous applications and they're not really sure what happened with it. And now they're trying to file again through, maybe a second spouse or children. You want to go ahead and do that so that you know what USCIS knows. Okay. Sometimes depending on, they can redact certain things from the file, but most of the time they're not going to redact like the vast majority of things. And sometimes you can see their notes in the margin. I've received files where you can clearly see a USCIS officer put like questionable marriage, or certain notes in the margin that you wouldn't even know was going to be in there, and answered so many questions about why a case was denied, right? So get your file, know what's in there. And typically, if you have ever received a green card, there's going to be record of it in your file. If you're trying to get if you're trying to say that you automatically became a citizen but you don't have you know proof that your parent got their citizenship or anything like that, they can request their immigration file or specifically request a copy of their certificate of naturalization, certificate of citizenship, to help you prove that you actually were automatically a citizen or that you acquired citizenship. So again, if you want to know what's in your file, if you want to get proof of your status, if you're just not sure what documents or anything that would be in your file, you need to go ahead and request it. That's really your best bet. Okay. Request it from USCIS, request it from the State Department. We typically do. Speaking of State Department, we typically do a Department request when people don't remember what they put in their DS-260 or DS-160. Meaning, when you're applying for your visa application, what did you put in the forms? If you can't remember, the best thing you need to do is go ahead and request that. If USCIS is saying that, oh, you put, that you were married and you had kids, and you're like, no, I didn't. Well, go ahead and request your file so that you can see what they're talking about if you actually did that. And sometimes people that are applying for a visa and that's in their file worked with an agent. They're not really the ones that actually filled out the forms. So the agent may have made a mistake and you wouldn't know until you go to a USCIS interview and they're asking you for a divorce decree, but you've never been married because the agent went and put that you were married on your visa application. You can find that out by getting a copy of your file from the State Department. So that's how you can get proof of your status. A FOIA request, FOIA request, Freedom of Information Act request, can be made to every single government agency. Okay? Every single government agency has a procedure for you to do a Freedom of Information Act request. So don't feel like you can't. Ask them for your documents. All right. If you have any questions, last call. Last call. If you have any questions, put them in the comments. I am more than happy to answer them. And if you are, if you have these questions or other questions and you would like a strategy session with me, you can do that by going to my website, lilylegal.com, or calling my office at 508-443-1788. All the details are always in the description to this video. And thank you so much for joining me. I do not see any comments. So thank y'all so much for joining me. And I will see you next week for more immigration talk.